Why is legal technology so bad? This is based on an article I wrote on Quora, which went just a tiny little bit viral and made me the most viewed writer in legal tech. I had someone call me. He made his pitch for his product and listened. I said, that's a great idea. It'll save attorneys hours every case and save thousands of dollars for the clients. No one will buy it. What do you mean no one will buy it? You said it was great. Yeah, but lawyers get paid by the hour. If you save them time, you cost them money. They'll never buy it. They'll say they're interested and they might buy it if maybe you could make a few changes, but they'll never buy. If you want to use the system, you're going to have to get the courts to mandate it. The legal tech entrepreneur I was talking to paused and told me that he hadn't made a single sale. He called me back 2 weeks later to thank me. He had done a press release aimed at courthouses and had just got an inquiry from the Canadian court system. His idea to automate document production and deposition scheduling was a good one. It just needed a receptive audience, and law firms just weren't it. When we talk about legal innovation in technology, what we're really meaning is this. Just because we call it innovation doesn't mean that it's actually innovative. And one of the big issues with that is that we just simply don't have the data. What other industry is it where becoming more efficient actually costs money? Where innovation is actually disincentivized? Is this the only reason that legal tech is so backward? More importantly, what can we do about it? Legal technology has the lowest venture capital investment rate of any industry. It's at least 15 years behind the technology industry in general. And during our marathon slog of cataloging every courthouse in America, we found a courthouse in Georgia where the clerk posts schedules on their website very diligently each morning in WordPerfect format. Cannot make this stuff up. Documents prepared in software that was obsolete 20 years ago, a format that practically no one can read, and with very little effort to change to Microsoft Word, could have easily fixed this. And yet this antiquated nonsense has lingered since the last century. One of the biggest problems we have is data, or rather the lack of it. There are 15 million civil lawsuits filed in America each year, 41,000 a day. America has 95% of the world's litigation, coming from just 5% of the world's population. So America is basically the only democracy to lack a loser pays rule, meaning there's no downside to bringing cases that have little or no merit. For plaintiffs' counsel, the courts are like casinos where if you lose, you're only out your time. The one and only upside from this disgraceful scenario is there's an awful lot of data to analyze. The problem is it's not in one place. The federal system has less than 2% of litigation, and though a reasonable number of states have integrated court systems, the norm is a county-by-county arrangement, and none of the states are linked. One could be forgiven for thinking it was a government operation. The major legal publishers have focused traditionally on appeals cases. The problem is that they represent less than 1% of litigation. 97% of cases rest at the circuit and county level and have essentially been ignored by the major publishers. Why? Well, federal courts are easy, state courts are not, said Amy Herovic in 10 Things I Learned While Falling in Love with Big Data. She detailed her time at Thomson Reuters attempting to acquire state court data. Someone would print out some case data, schlep it to the other side of the courthouse where someone else would scan it back in again, enter some fields manually, and then upload it to their database. Measure it, though, with stopwatches to get it efficient, though. It's a huge amount of effort to do across the country 41,000 times a day. And not surprisingly, they couldn't get anywhere close to a national system. Our artificial intelligence can handle the same activity in less than a second, while reading and understanding the case too. Automation and machine learning are why a startup from nowhere has been able to cover over 87% of US free cases in less than a year. With data comes transparency, and transparency, as we shall see, is where every positive change in law will begin. Buyers aren't users. The purchaser of legal technology is rarely the person who actually uses it. Why is this a problem? Imagine you're going to buy someone his or her first car. You might buy them a 5-year-old Honda. It's affordable, reliable, meets your travel needs. It's not going to go from 0 to 60 in 3.2 seconds or get parked next to a valet stand, but it's all they need. Now imagine it's a car for you to drive. You likely buy a Mercedes. It'll be new and it'll come with a warranty, and you're going to be the one using it, so soft factors and all those little details that make driving a Mercedes great come into play. Ravel Law came out with a new citation system. It's pretty and clever, and probably one of the best on the market. It was easily the Mercedes of citation systems. And if I was doing legal research, it would be what I would want to use. It wasn't a big seller though, and LexisNexis and Westlaw have marketing clout that's hard to beat, as no one ever got fired for buying IBM. So buying their citation system is a safe, conservative move. In the end, they actually wound up buying Ravel Law. Law firms are all about safety and conservatism. If you don't have to use the system yourself, the fact that it might be nicer to use is irrelevant. Users don't decide, and decision makers don't use. Why bother innovating if there's no incentive to? If you've used citation systems, it's painfully obvious they're basically 1980s technology, terrible and expensive. Why? Because they can be. Where are clients going to go? The hourly rate. If there's one thing that's been picked to death in law, it's the hourly rate. Its demise has been predicted for decades, yet it still lingers like the last guest at a party. What's the point of being efficient if your opponent is paid to drag things out? There's the age-old argument that you don't know how long something's going to go for in litigation, so you can't really estimate the costs. This is a lie we tell ourselves. Let's take a look at the average civil lawsuit billing. The client visits a lawyer. The lawyer assures the client that they know what they're doing. The lawyer says the case should be finished in around $25,000 and takes this as a retainer. Then he'll spend the next 40 minutes issue spotting to the client's irritation. Over the course of the next month or so, the $25,000 retainer is depleted rapidly. The client worries it may run out and calls the lawyer to ask, "Don't worry, the beginning is the most expensive bit, where we do the most work," the client is told. A few weeks later, the lawyer calls the client and tells them that he misrepresented the complexities of a case and it's actually going to be closer to $50,000 in total cost. The client is obviously annoyed, but realizes that swapping attorneys will lose his sunk costs of getting the lawyer knowledgeable on the case. So he spends another $25,000, which is chewed up with frivolous back and forth motions accomplishing little. At the $50,000 mark, the client receives another request for funds to get through depositions. "Don't worry, we're almost at the winning post," he's told. He grudgingly parts with another $30,000 to finish the case. The case actually costs $20,000 after that, but $100,000. If he, quote-unquote, wins, there's a good chance he won't be able to collect enough to pay his legal bills, and if he's defendant, he won't get his legal fees back. Is the lawyer not aware that the case is likely to run to $100,000 when he quotes $25,000? After all, he's done dozens before. Of course he is. Is he merely being optimistic? No, he's lying. Why? It's because he has to. If he doesn't, the client will go to an attorney down the street who tells him what he wants to hear. It's a race to the bottom. One could argue the client is being naive and gets what he deserves. Most clients are unsophisticated purchasers of legal services. Even general counsel, themselves former litigators, are woefully ignorant of likely costs and outcomes. Our United Kingdom litigation study, the country's largest ever, found that corporate selection of law firms was 18% worse than random. Why do people make such bad choices when hiring and managing lawyers? Because they lack the data. They lack transparency. I've stated before that every major change for good in law will come from transparency. Peter Diamandis said, most evil is done in the dark. People do bad things, deliver bad service, break their promises for one reason and one reason only. They can get away with it. No one sees and no one notices. Imagine the same scenario where there's a sign in front of a lawyer's office saying, lawsuit $100,000. He can't claim it's $25,000 anymore. If the same sign sits outside his competitors' offices, then they can't lie anymore. So now he doesn't have to go to do that either, to go down the street. The client goes into the lawsuit with his eyes open, or maybe he decides it's not worth it and gets on with his life. Let's add to the sign. Take a look at this chart. This is case durations for divorce lawyers in Orlando, Florida. Imagine being the outlier on this chart. And it says average case duration over 1,000 days on his sign. How many people will use him? None. He can't repeatedly take advantage of clients because they can finally see him for the clock runner he is. The market becomes efficient, regulates itself because of performance transparency. How much would you pay for a lawyer in the left-hand box? Many consumers would happily pay double the going rate because they're getting a fast, quality service. For the lawyers who currently suffer by limiting their billing and doing a fast job, the increase in the number of clients contacting them and the increased amounts they're willing to pay will more than offset their losses from not dragging out litigation. How much does a lawsuit cost? Well, we found at Premonition in some of the largest legal studies of all time that if you pay 100% more for a lawyer, you only get a 3% better performance. Let's add one final item to the sign, performance. This is the UK Court of Appeals. It's the battleground for the finest legal minds on earth. Some of these lawyers, barristers, cost over $8,000 an hour. You would think at that kind of money with those kind of stakes that the lawyers that choose these people would know how good they are. But you would be wrong. This is Mr. Popular. He's been 41 times in the last 3 years. Has a 60% win rate. Not a bad barrister, but he's not the best. These guys are best. This one has 7 straight wins. Crazy thing is that when Mr. Popular is not available, the major law firms like to hire these 3 monkeys down here. Second, third, and fifth most popular lawyers in the UK Court of Appeals have win rates in the 20s. You are better off representing yourself than hiring these proven losers because pro se litigants typically average 42% in this court, though the mileage varies significantly from judge to judge. Because of this anomaly, law firm's choice of barrister is actually 37% worse than random, as we see here. So where does this information lead us? Transparency and an efficient market. When consumers can compare their litigators by price, case duration, performance, magical things start to happen. The worst performers find something else to do. Litigators can't run their clocks anymore. An efficient market brings competition, brings price comparison. The best people can earn more. One of the problems in law at the moment is not necessarily that lawyers are expensive, is that people don't get value for money. A great lawyer is worth a lot more than the US $1,200 ceiling that we have right now, but those people can't prove it. And the worst lawyers must discount, find some other way to compete, like speed or performance guarantees, or they've got to exit the market. Now, not everyone can be number 1 or even number 10. And Lawyers that don't have top win rates can still be competitive. How is that? By being faster or cheaper than their better performing peers. 60 days quicker might be worth 6% in performance. Study after study has shown that consumers actually not only prefer flat fee pricing, but they'll happily pay more for it, 20% more. Lawyers offering $120,000 flat fee litigation that could potentially cost $80,000 or more if it goes to trial might actually find themselves not only competitive but attracting more clients when consumers can see 25,000 case estimates for the nonsense they actually are. What's happened here? Well, the lawyer has just made 20% more money for no extra work. Even more so, he now has an incentive to be efficient. Let's take this a step further. The lawyer who's just discovered he can make more money by charging flat fees breaks the billing down into stages. $10,000 to onboard and send out a response to a complaint, $10,000 for document production and setting deposition dates, $10,000 for document review, $20,000 for motions, $30,000 for depositions, $20,000 for settlement discussions, or $300,000 if it's going to trial. Now, he has a serious incentive to be efficient. Let's say he subcontracts a client onboarding to a team in India. Some of the best people in the country research and draft pleadings for $2,000. He puts $8,000 in his pocket and has all the extra hours free to bill another client on another matter. He finds out opposing counsel is also on a flat fee arrangement. Let's use this new service that automatically manages document production and scheduling. It only costs $500 a case, he suggests. They both make an immediate $9,500 profit and spend the time saved marketing and seeing potential clients. If opposing counsel is on the clock, time spent filing motions is going to be less. Why? Because he's only going to file something if it's absolutely necessary to the case. Maybe he does the depositions himself, or maybe he subcontracts them to another lawyer in town who specializes in them. It's likely going to be someone who has the ability to extract the most amount of information in the least amount of time. At the very least, fishing expeditions will stop. Settlement negotiations are faster because it costs to drag them on. A 1-hour settlement is a $20,000 hour. That's decent money and far surpasses what he'd make on an hourly model. Now that cases take up much less of his time, he can do more of them, many more. A model like this scales. He can stamp out the process over and over and over again, thousands and thousands and thousands of times. Before, the lawyer was limited to 2,000 to 2,500 hours a year. Now, there would be no limit. Earnings aren't capped, and they have every incentive to be efficient. He can be a little cheaper than his competitors and a little faster. This is a rising tide. Everyone benefits, and it all starts with transparency. Finally, technology can have a place in law. How do you become efficient quickly? The same way as every other industry. Technology and lots of it. Technology to do everything technology possibly can do. You've got a bot that can draft a motion. Let's talk. Software that can transcribe dispositions in real time. Let's buy a license. Not waiting for a transcript was going to save me 30 days off my case durations, which will bring in more clients. The e-discovery document crawlers that can read a deposition and highlight the lies. Wow, let me get my checkbook. Transparency brings about an efficient market, and an efficient market begets yet more efficiency. When law moves to standard flat fee billing, many wonderful things happen. Law will get cheap and law will get fast. Time finally equals money to law firms. And lawyers will push opposing counsel to be quicker, to settle sooner. Aggressive representation is finally rewarded because client outcomes become far closer aligned with legal outcomes. One of the many reasons why people hate lawyers so much is because their incentives are so grossly disproportionate to the clients. The client just simply wants the case over with, but the lawyer is actually paid to push it out, which is ridiculous. Time-wasting starts to get eliminated, actually pays to implement technology, to do automation, to bring in artificial intelligence. So it gets to a point where legal innovation with the quote marks actually becomes legal innovation without quote marks, because legal innovation finally be a real thing and not something that people pretend. We have found at Premonition that simply picking lawyers by the numbers gets results that are either 50% better and 50% cheaper than simply hiring a major law firm. As we've seen, every great change in law comes from transparency. That is where it all starts. Finally, will people stop hating lawyers? Perhaps too much to ask. If you've enjoyed this, check out many of our free reports at Premonition, and don't forget to like, share and subscribe. Thank you so much for watching. See you next time.